Okay, and welcome to our webinar today, which is the legal implications of cloud computing. I hope everybody can see the presentation, so please let me know if you can't. So today I'm going to just give you an overview of who I am and who e.law is. We'll look at what the risks of cloud computing are, what actually is cloud computing, what are the legal issues, any privacy considerations, how to conduct due diligence, any security issues, regulatory compliance issues, any discovery issues, and then we'll look at the USA and give that a special mention given in particular the Patriot Act there. So just an overview, e.law has been around since 1999 and so has been in operation for just over 15 years. We actually provide end-to-end digital services, so what that means is we can assist in collection of the digital evidence, processing of the evidence, and then ultimately presentation of the evidence in court or running electronic courts. We also provide cloud-based solutions for lawyers to access and review evidence within Australia. So as a consequence of this, we've actually, identified several interesting issues with respect to cloud computing. So just my background is I was formerly a practicing lawyer and actually worked in the courts in Queensland before setting up e.law. So what is cloud computing? What's actually offered? So cloud computing can comprise firstly infrastructure as a service, so that's where the hardware and so on is essentially rented, and I'll explain a bit more about how this works shortly. A platform, so particular applications, that sort of thing that can be provided, or finally software as a service, and this is what we often provide in the legal review sphere. So we simply license the lawyers certain software in order to conduct a review for discovery. So it's pretty much just user pays as you go. And that's pretty much a combination of these because the hardware is actually hosted in the cloud as well. So how does cloud computing work? Well, firstly, it means that users can rent server space in order to store data, and how this works is imagine that you've got your servers in a server room in your office, and they may have a storage capacity of, say, 1 terabyte, but you may not necessarily use all of that terabyte for your own storage. You may only use at times 200 gigabytes, 400 gigabytes, whatever it might be, which means that the remainder is there being underutilised. So cloud providers essentially offer that terabyte, for example, but they will chop that up into various sizes on the hard drive. So you'll have various what they call virtual computers on the one server, which means it can now rent out that server to a number of different users and maximise the space on the server. Now the benefit of this is that it means that internally you no longer have to purchase hardware up front. You no longer then have to worry about depreciating it and replacing it when it has been depreciated. You don't need to purchase software to reside on the hardware, and arguably you don't need IT staff to actually manage the infrastructure and the software licensing. So that's all managed for you, and you pay a service fee for that. So you can see that potentially there's that cost saving or cost effectiveness in server space being available in that virtual environment. It means that the cloud provider can also move data from one place to another for load balancing, thereby increasing efficiency in the data storage capacity. What this means is they may have some of your data on a server in one place and some of your data, if there's no more room on the server or servers in that location, they may have some of your data in another location, which means that they're able to spread the load and again thereby maximise their use of servers across various locations. So some of the risks, and we'll look at these in a bit more detail, but firstly, the contract. What does a cloud computing contract cover? We'll look at privacy breaches, and we'll spend a bit of time looking at what those are in Australia. Look at any security breaches at the data centre, loss of data, loss of control over the data, what happens if the cloud provider goes under, what happens to your data then, disaster recovery, termination, subsequent data migration, and local versus offshoring. So the risks in cloud computing are essentially looking at mitigating against the risks, and this is all about due diligence. Firstly, start with the contract, and generally it's about cost versus control. So essentially, if you're giving up control of your data, then ostensibly the costs can be reduced. So more control usually means it is a bit more costly. For some of the legal issues, consider control of the data, location of the data or the jurisdiction, cross-border enforcement, look at the contract and any privacy considerations. So looking at control of the data, who has control? Is it like storing boxes in a warehouse? Well, a couple of recent cases looked at this and say that electronic information is intangible and capable of being owned. Sorry, incapable of being owned. In Your Response Limited against Data Team Business Media Limited, the English Court of Appeal held that a database was an intangible asset and the law did not regard this as property. Accordingly, it was not subject to a shows in action. So this raises an interesting point about the control of the data from a legal perspective. In Dixon and the Queen, the New Zealand Court of Appeal had to look at whether a digital video recording was property and capable of being stolen. The court said while the hard disk could be stolen, the information stored upon it could not. Now it's interesting in that case because the court actually considered the wording of the legislation that applied in this particular case, and they made the point that arguably that the wording perhaps was not adequate, that potentially databases potentially could be property and could be owned, but it wasn't the court's place to change the law, and that was up to the legislature. So I think it's important to watch this space, particularly given that if you juxtapose the situation in the law of intellectual property and intangible assets, arguably you could say that intangible assets are capable of ownership and being protected by copyright and other intellectual property laws. So, yeah, I think certainly one to watch in the coming months and years. So who has jurisdiction over the data? There's a recent decision of the New York District Court. I don't actually have a citation for this particular matter because it appears to have been a matter that was mentioned, doesn't seem to have a long judgment, but it was widely reported in blogs and so on social media. There, US District Judge Loretta Preska, and this judge is I think one of the judges, or one of the few judges in the US well known for, I guess, making rulings that, seem to have some logic applied when it comes to digital evidence. And she ruled that Microsoft had to turn over a customer's emails that were stored in a data centre in Ireland, and they had to be handed over to the US government. Microsoft, along with other US companies, they challenged a criminal search warrant for the emails, saying that federal prosecutors can't seize customer information that's held in foreign companies. The judge there ruled that the warrant lawfully required the company to hand over any data it controlled, regardless of where it was stored. The judge said it's a question of control, not a question of the location of the information. So very interesting. Microsoft intends to appeal, so again this is one to watch. That was a very recent decision, so keep an eye on what happens there, and we'll certainly blog about that once we have the decision on appeal. So in Australia, there actually may be some limitations to storing data offshore. APRA requires notification of any transfer of data offshore by financial services institutions, and that falls within the Financial Sector Collection of Data Act 2001, which is a Commonwealth Act, and that forms under Form ARF 321.0, Statement of Financial Position Offshore Operations. Some government departments may have a blanket prohibition on storing data offshore. And I guess it also affects any remedies. So remedies that you might expect to have available in Australian courts may simply not be available in an offshore jurisdiction. The other danger is that if data is stored offshore, then data may be subject to the investigative powers or seizure powers of regulatory authorities in these offshore countries. So, yeah, I just think just be aware of that. Certainly a user may not be aware that their data has been seized by another government. And then finally, obviously, you need to find a nexus between the dispute and the court in which the dispute is being brought. So another thing to bear in mind with respect to cross-border enforcement is that privacy considerations. So the laws that we have here in Australia simply may not be the same, or they may not even have privacy laws overseas. And then any offences for which people are liable might be different in various jurisdictions. Okay, now turning to the contract, what to look for. So firstly, what does the contract cover? Does it cover infrastructure, software support, or does it cover all three? Does the contract provide a liability for damages if there's an interruption in service? What services are covered and between what hours? How can the user access the data in the event of loss? How can the user be sure that the integrity of the data will be maintained? Where is the data being stored? I think you need to know that. Termination, so avoid vendor lock-in. Now, vendor lock-in is where a user is forced to use a cloud computing vendor's particular software regime. Personally, I don't have too many worries about this. I think we're all pretty much locked into a particular vendor's software anyway. I mean, if you look at Microsoft, I think we've all tried to open up, Word documents or other Office files in another application, and it can cause all sorts of grief. Even, if you've ever done a bit of work where formatting is particularly important and you've transferred it to an Apple Mac and opened it up in Office for Mac, that can cause all sorts of dramas. I've had a headache with just formatting documents being all over the place. So yes, try and look for being locked into proprietary software, but I guess just keep it into perspective, given we all have to have our content read by a particular software in any event. Insolvency events, so how do you cover off the cloud provider going under? Obviously do due diligence on the company itself, see what the contract says about these events, make sure that you have a right to obtain your data. But at the end of the day, always make sure that you have the ability to back up any data that you have stored in the cloud. Have regular systems for ensuring that you have that backup done. So in the event something happens, you are not caught short without your data. Data retention, how long will data be stored before it's deleted by a vendor, and is there any charge for that? Intellectual property rights, so is the intellectual property yours? Make sure that's covered. What's the security surrounding the data centre? Look at disaster recovery, and then any migration of data that you may need to do. Make sure that you are able to do that in consultation with the vendor. All right, so looking at privacy considerations. So we recently had an amendment to the Privacy Act, the Commonwealth Act, following a fairly comprehensive review by the Australian Law Reform Commission. So the privacy principles used to be known as the national privacy principles, but now they're the Australian privacy principles. Personal information is defined in section 4 and includes any biometric data. So that would include fingerprints and so on, or you know, retina prints, body samples and so on. And Schedule 1 of the Act contains 13 Australian privacy principles. Bear in mind too that health data such as medical records are actually subject to the Health Records and Information Privacy Act 2002, which is a Commonwealth Act. So the Privacy Act, for private organisations, the Australian privacy principles are applicable. And then for government agencies, Commonwealth government agencies, there's information protection principles as well. So the 13 Australian privacy principles are set out here. Open and transparent management of personal information. 2, anonymity and pseudonymity. 3, collection of solicited personal information. 4, dealing with unsolicited personal information. 5, notification of the collection of personal information. 6, use or disclosure of personal information. 7, direct marketing. 8, cross-border disclosure of personal information. 9, adoption, use or disclosure of government-related identifiers. 10, quality of personal information. 11, security of personal information. 12, access to personal information. And lastly, correction of personal information. So the two that I draw your attention to are Privacy Principle 8, which deals with trans-border data flows. It says there that an entity in Australia may only transfer personal information about an entity or an individual to someone other than the entity or the individual who is in a foreign country only if certain criteria are satisfied. Then there's Australian Privacy Principle 11 on security of personal information. That says an organisation must take reasonable steps to protect the personal information it holds from misuse and loss and from unauthorised access, modification or disclosure. What are the remedies for breach? Yeah, look, there's various powers that the Privacy Commissioner has, you know, to give an apology, order a change in practices, order for access, amendment, deletion, and even order for compensation. I'm not aware personally of any cases where compensation has been significant for a breach of privacy. So again, I think it's one of these, you know, watch these spaces types of scenarios. At common law, there actually is no right to privacy. In Victoria Park Racing and Recreation Grounds against Taylor, which was a 1937 Commonwealth Law Reports case, Chief Justice Latham at the time said, any person is entitled to look over the plaintiff's fence and to see what goes on in the plaintiff's land. If the plaintiff desires to prevent this, the plaintiff can erect a high fence. Then in 2003, in the District Court in Queensland, Judge Skane actually looked at this and thought that it was a logical and desirable step that it be recognised that there is a civil action for damages based on the actionable right of an individual person to privacy. So he actually identified the following elements for a breach of privacy. Firstly, a willed act by the defendant. Secondly, which intrudes upon the privacy or seclusion of the plaintiff. 3, in a manner which would be considered highly offensive to a reasonable person of ordinary sensibilities. And finally, which causes the plaintiff detriment in the form of mental, psychological or emotional harm or distress, which prevents or hinders the plaintiff from doing an act which she's unlawfully entitled to do. So I'm not aware that courts have taken this a step further, certainly the higher courts, but it's, I guess, a step in the right direction to have that common law right recognised. But we certainly do have legislative provisions at the Commonwealth level. So internationally, in the US, nearly all US states now recognise either a statutory right to privacy or a common law. The European Union, the European Convention on Human Rights contains a right to private and family life, home and correspondence. It's interesting to note that in April 2014 the European Union rejected wide data retention laws that would force telephone companies to keep citizens' communications data up for 2 years. In the UK we have the Data Protection Act 1998, and at common law, English law knows no common law tort of invasion of privacy, and that was confirmed by the courts in 2007. In Canada, similarly, there's no common law right, there's no common law tort of invasion of privacy, although several of their provinces have a statutory cause of action for an invasion of privacy. So that's in British Columbia, Manitoba, Saskatchewan, Newfoundland and Labrador. In New Zealand, at common law, they have actually recognised a common law tort of privacy. So various international standards there, and obviously you need to consider each on a case-by-case basis depending on where a matter is at the time. Alright, so what to look for? Firstly, how will your data be stored and in what format? Where's the data going to be stored? Who has access to the data? If it's to be replicated to more than one site, where are the sites and how's this done? What are the technical controls? What are the security? And we'll look at security in a bit more detail in a moment. See the documentation and ask to see test results. Actually go and have a look at the data centre, or certainly get your technical people to do that. Use the system on a trial basis and of course carry out any reference checks. From a security perspective, do some practical checks. So look at physical security, data security, encryption and auditing. Most data centres now would have pretty extensive physical security, so you'd need to have authorisation to actually get in the front door, and then various forms of security in order to get to the racks. Data security, there's should be layers of firewalls and so on at the data centre itself to protect any data that lies behind those firewalls. Get your technical people to check the encryption. So is it being done for the whole data flow or only at certain points, because they can be important. And then if encryption keys are lost, can you actually get your data back? Because often without a key that can be problematic. And then auditing, request certifications, ask how regularly these are done, and more importantly, ask whether random penetration testing is done. That's important to see if basically that's a friendly hacker will come in and see if they can actually break through the firewalls and so on that is around the data center. And most data centers should actually have that done. Okay, so there is an international standard 27001 which can be used as a guide to check for security and to generally if the data center does have this accreditation, then it has been audited to meet the criteria set out in the international standard. So it's certainly a good starting point. So the standard covers a risk assessment, ensuring that management has a strict security policy in place, that there's appropriate governance of information security, appropriate asset management, human resources security. So this is often forgotten. You know, people spend a lot of time getting the software and the hardware and everything else right, which is all well and good, and then forget that someone may be happy to give information down at the local hotel on a Friday night for cash in hand. So security for employees, that needs to be in place. Employees need to be vetted. Depending on how confidential the information is, you may require them to have police checks and so on. So if you do have secure data, then ask the questions. What's your security vetting policy? How do I know that people who are providing information on these racks are appropriately vetted and so on. Physical and environmental security, so appropriate protection for the computer facility, so that's things such as fire protection, appropriate air conditioning. If you've ever been to one of these data centres, you know, they look like something out of a sci-fi movie. They're usually very large rooms. They have underfloor facilities available to put all of the cabling. They have appropriate fire retardants everywhere, and you know, everything is very well maintained. All of the cabling is appropriately put away, and so on. So it should look, you know, neat and tidy, and you know, there shouldn't be cords lying around for people to trip over and so on. Look at the communications and operations management, making sure that appropriately skilled personnel are managing that there's the appropriate technical security controls in place. And generally, people often say, well, you know, I'd be worried about my information being stored at a data center or in the cloud, because how do we know it's secure? Generally, data centers have to go through this, and generally most of them would have this certification according to this international standard, whereas most organisations don't. So, you know, any company that's, say, even around Sydney, that has information sitting on their own servers potentially haven't been through this level of security vetting, and potentially are a lot more wide open than their information would be in a data centre. So, you know, one of the arguments for storing information in the cloud is simply that getting these security requirements ticked off is expensive. Maintaining that security level can be expensive. Yet, as a user, if you're putting your information in the cloud, you get the benefit of, you know, more than just you having that available, so it can be a lot more cost effective, and you can actually get better security around your data than you could possibly hope to get internally. Access control, so restriction of rights, of access rights and so on, as you would in any network. Information systems acquisition, development and maintenance, so you know, has security been built into the databases, etc. Information security incident management, so making sure that if something does happen, there's appropriate reporting so that you know about it as soon as it happens, not on the front page of the local paper. Business continuity management, that's just, I guess, general good governance procedures, making sure that business critical processes and systems are maintained. And then finally, compliance, making sure information security policies, standards, laws and regulations are all adhered to. So now turning to regulatory compliance, this is going to be different obviously for every business. If you're in the financial industry, you may need to look at APRA standards and guidelines. Depending on, you know, what type of business you're in, you'll just need to look at any potential, you know, obligations you may have, particularly around confidentiality and integrity of sensitive information. Make sure that you're aware of the Privacy Act provisions. You know, you may need to ensure that personal information is deleted or that it's otherwise appropriately dealt with under the Act. And then finally, make sure that you do comply with the Corporations Act. Okay, so turning now to discovery. So at e.law, I guess this is what we do day in, day out. When I first started this business, discovery was generally about hard copy documents. So we would get them, we'd scan them in, we'd data code them, put them in a database, and for large matters that was, you know, didn't make sense and made, excuse me, made, you know, search and retrieval of the information much easier. These days, or more recently, it's all about obtaining electronic information, generally from hard drives, sometimes backup tapes, sometimes servers. Bringing that information together, you know, reviewing it, analysing it, working with the legal team to get down to, I guess, a relevant set, so a set of information that's relevant to the issues, and again using appropriate systems to manage that discovery set. These days, a lot of information is now being stored in the cloud. So it's no longer a case of getting access to hard drives and so on. It's getting, username and password and downloading the information from the particular cloud environment. So, there may be issues around getting access to the data. So I guess the first question, and every jurisdiction is slightly different, but generally the question is that it needs to be in the user's possession, custody or control. Now cloud contract may say that a user doesn't own the data, or the cloud vendor is in control of the data. So you may have an issue there. And also, what if the user refuses to provide usernames and passwords? What happens there? I'll come back to that in a moment. So with the discovery, we generally work to an international model, which is on this particular slide. It's called the Electronic Discovery Reference Model, and until recently started off at the red box, which is called identification. More recently, it's been extended out to include information governance, and I'll explain why in a moment. But just generally looking at the diagram, you'll see on the left-hand side the yellow triangle with volume in it means that we start off with a very large volume of electronic information, and the idea is that as the volume decreases, then the relevance on the right-hand side increases. And the way this is done is going through this electronic discovery cycle, starting with identification of the data, preservation of the data, collection of the data, processing it, reviewing it, analysing, producing it, and then ultimately presenting it in court. So hopefully by the time you get to court, you're left with nothing but relevant material. Now the reason information governance has recently been added is because a lot of organisations have realised that simply storing a whole pile of information on servers, backup tapes, completely unstructured, completely sometimes unlabelled, can be an expensive process to locate and retrieve the information if a discovery order is served. So corporations are now interested in ensuring that their electronic information is able to be interrogated depending on dates and depending on whose data is relevant, for example, email repositories and so on. So there's a lot more work going into archiving and record-keeping practices to ensure that the information is now litigation ready, so that if a matter does need to go to court, corporations can lay their hands on the information quickly and easily. I mean, these days it's, the way in which information is stored is completely different. Gone are the days of hard copy information being stored in manila folders in filing cabinets, and instead it's a bit more of the case of unstructured data, lying on data networks and of course now in the cloud. So the tools that are being developed are quite good at looking at unstructured data and helping lawyers, I guess, find what they're looking for, even when they don't know what they're looking for. So of course one thing that crops up when you're talking about discovery and digital evidence is social media, which is, as we know, is now ubiquitous. So what happens if you do need to discover information off social media? It may be relevant, third-party subpoenas may be required, so of course you need to show how it's relevant and that the scope of discovery is limited in order to avoid unnecessary cost and delay. There's no Australian cases of which we're aware that really deals with this issue on point, but there's several US cases, and some of the ones I've mentioned here are Offenbach and Bowman, where the judge privately reviewed the information in advance to determine if it should be disclosed. In Barnes and CUS National, a judge became friends with the party to determine if private Facebook posts were relevant. Largent and Reed, where the judge required parties to turn over physical access, so that is the username and passwords for social media accounts, to the other party. And finally in Leicester and Allied Concrete Co., where a court fined both a party and his lawyer for cleaning up a Facebook page to remove harmful posts and pictures. So this is another space to be watched. So finally, the USA has special mentions. So you may be aware that the USA has the Patriot Act, which is an acronym for Uniting and Strengthening America by providing appropriate tools required to intercept and obstruct Terrorism Act of 2001. The purpose of this act is to target terrorism, and it says that it's not intended to grant unfettered access to data. It does apply to any company with a presence in the USA regardless of where the data is held. So for example, Microsoft, which is a USA corporation, is about to open data centres here in Australia, so ostensibly anything stored in that data centre would be subject to this USA Patriot Act. Other countries do have mutual treaties honouring this agreement as well, or this legislation. The USA also has the Stored Communications Act. There, a valid subpoena issued in relation to a criminal investigation can compel disclosure of basic subscriber records. And a search warrant showing probable cause can compel disclosure of stored contents of any account, including messages, photos, videos, etc. And it's interesting that Facebook makes it clear in its data use policy that information may be disclosed pursuant to a legal request, including those outside of the USA. Now it's interesting looking at a subpoena can be issued which can compel disclosure of basic subscriber information. Now you may recall recently the Attorney General George Brandis was in a bit of hot water because he couldn't really explain what metadata was. So that is in relation to metadata that is kept about subscriber records and information. So Australia is also keeping that those records as well. All right, well, I'll leave time for any questions. Otherwise, my contact details are here. If anybody would like to send me an email, if you have any direct questions or would like some further information, please feel free to send me an email. Of course, you can telephone me as well, but generally email is the fastest way to get hold of me. I hope you enjoyed that webinar, and hope you found of interest some of those issues dealing with cloud computing. Thanks very much.